चलो, so we shall start with question number 226. Till 225 we have already done, and in today's handout also I have given some notes about parliamentary committees. Have you seen? Because in last class we were discussing कि parliamentary committees करने में दिक्कत होता है. So that in summary format what we have also covered in the PMP classes. तो वही वाला उठा के मैंने यहाँ पे डाला हुआ है. So that is giving at least whatever the important parliamentary committees are, उसका tabulated format में I have kept it in that notes also, right? So let's start with question number 226. By today, I think that we shall be able to complete state legislature and parliament. And then for the next class, we will be doing in one class judiciary, in one class center-state relationship and emergency, in one class elections and representation of People's Act. So this will be around 150 more questions. And 50 to 60 questions directly I will be making from the Bear Act. जो बेयर एक्ट में प्रोविजंस होते हैं उस पे क्वेश्चंस हम लोग डायरेक्टली करेंगे. बिकॉज एट दिस पॉइंट ऑफ टाइम इफ यू हैव नॉट ऑलरेडी रेड द बेयर एक्ट इट विल बी हार्ड फॉर यू टू रीड. तो उसको हम क्वेश्चन के फॉर्मेट में सारे जो मिसलेनियस काइंड्स ऑफ प्रोविजंस है फंडामेंटल राइट्स वाले नहीं करेंगे. वी विल बी डूइंग फ्रॉम यू से ट्रेड एंड कॉमर्स आर्टिकल 301, 2, 3, 4, 312 यूनियन पब्लिक सर्विस कमीशन, वैसे जो ट्रिवियल पॉइंट्स है उसको विल बी डूइंग डायरेक्टली फ्रॉम द बेयर एक्ट, राइट? ओके. So question number 226, when demands for grants are introduced in the Lok Sabha, the speaker applies the bulletin when? After the demands are discussed and approved, after the demands are discussed and voted down by the Lok Sabha, when the demands are discussed and reduced, when the time allotted is coming to a close. So the answer to question number 226 is when we apply bulletin on something. D. Is that when the time which has been allotted to it that is coming to close, so you cannot extend it further, the speaker shall apply the bulletin closure, right? So the answer here is D. 227, the method of election of members of Rajya Sabha based upon proportional representation by the state legislature, and this was borrowed from the constitution of the method of election what we are following today is, it was from South Africa. It is borrowed from the constitution of South Africa. Then question number 228, which one of the following statements is not correct? There is a provision in the Constitution of India for the readjustment of allocation of seats in the Lok Sabha upon completion of each census. So this is true. Ideally, it has to be done every 10 years after the census has been completed. So after 10 years, we have a census. उसके बाद delimitation करना होता है. This is Article 82. It is for the period of 60 days, a member of either house who is absent without the permission of house from all meetings thereof, his seats may be declared as vacant. 60 days. This is in the Constitution. It is written in the Constitution. So the rule says that if any member of the House who is absent for a period of continuous 60 days, his or her seats will be vacated. Now, provided that two conditions should be there. One is he has not taken the prior permission, and secondly, the duration for which the House is not in session itself, that will not be counted. Right? Suppose that a person who is absent for 6 days, and on the 7th day the House went out of session and it comes to session again after 3 months. So these 3 months will not be counted. Again the House comes to session and the person is still continuing to be absent, then onwards again it will be counted, और पीछे का 6 दिन और आगे का 54 days मिला के उसकी 60 days निकाली जाएगी. Right? So this provision is also true. Rajya Sabha has to pass the money bill after it has been passed by the Lok Sabha. This is not mandatory. Either Rajya Sabha can pass, can return, or cannot do anything, but the only limitation here is for 14 days. Within 14 days, they will have to do whatever they want to do, right? So this statement is not correct here. Fourth one is also correct. Now question number 229, which one of the following schedules of the Indian Constitution deals with allocation of seats? Fourth schedule, right? Fourth schedule. Under Article 312 of the Constitution of India, the Rajya Sabha has exclusive power with regards to what? Creation of all India services. What is the process? firstly Rajya Sabha will be passing a resolution with a majority of 2/3 present and voting, and then Parliament may together create the new All India services. So Article 312 relates to creation of new All India services. Vote of credit. Vote of credit provides for what? Vote of credit provides for that one is called as blank check. So what is it for? Either an exceptional grant which forms no part of current services of any financial year, any grant in advance in respect of estimated expenditure for a part of any financial year, a grant for meeting unexpected demands upon resources of India on account of magnitude of services of indefinite character, and fourth, a grant for additional expenditure upon new services not contemplated in the financial year. So answer here is C. Answer here is C, right? Upon those services which cannot be disclosed before the Parliament. For that, we give what? Vote of credit. Now, the advance grant, it is known by the name vote on account. Vote on account. So it's a similar name. You should not be confusing. This is called vote on account. For the time being, say if the budget cannot be completed before 1st of April, but from the 1st of April, the expenditures will be starting. So for this interim period, Parliament passes what? Vote on account, right? This first one is related to exceptional grant. This is called exceptional grant. For those services, any exceptional services, any special services which do not form the part of current year, already it is not conceived, right? But those for special purposes, if it comes to later during the financial year, Parliament can grant exceptional grant, right? Okay. Yes. Current, of course, current financial year. It's like कि अगर किसी साल अगर ऐसा नहीं हुआ बजट में, है ना? And there is also one thing that if suppose Parliament has approved a sum of money for a particular demand, but that is found insufficient during the financial year, then which kinds of grant is demanded? Supplementary grant. This was demanded by government in the December this time. So supplementary grant. मान लो कि नमामि गंगे स्कीम के लिए 1000 करोड़ सैंक्शन कर लिया पार्लियामेंट ने, बट खर्च करते करते लगा कि अब इसमें एक साल का खर्चा नहीं होगा, then government can bring in what? Supplementary grant. So that is called supplementary grant. Now question number 232. Consider the following statements. A bill returned by the President for reconsideration does not lapse on the dissolution of the Lok Sabha. Second, a bill passed by the Lok Sabha and pending in the Rajya Sabha lapses on the dissolution of the Lok Sabha. Third, a bill under the consideration of the Lok Sabha lapses when the Lok Sabha is prorogued. Fourth, a bill pending in the Rajya Sabha but not passed by the Lok Sabha does not lapse on the dissolution of the Lok Sabha. This kinds of question we have already discussed in the previous class also, right? See the statement number 3 first. It is saying that upon prorogation, this will be false. There is no effect upon any bills due to the prorogation of the House. Only the dissolution of the Lok Sabha will have. But if there is any pending motions in the House, that will lapse. Motions or bill में फर्क होता है. If any motion is there and the House is prorogued, that will lapse, right? But not the bills. So this statement is false. The rest other are correct. Our answer is D. During the discussion, question number 233, during the discussions on the demand for grant, cut motions can be moved to reduce the amount of a demand. Which of the following categories are classified? Which are the categories of the cut motions? There are 3 kinds of cut motions. कौन-कौन से होते हैं? Policy cut, economic cut, and token cut. There is no such thing called program cut. It's policy cut. It's not program cut. Right. So in policy cut, what happens? The overall allocation, the final allocation to any demand is reduced to rupees 1. 1 रुपए ही allot करेंगे. And you cannot technically do anything under 1 रुपए. 1 रुपए में कोई भी scheme policy नहीं चलाई जा सकती. So that is as good as nothing. Right. In economic cut, they will reduce by a specific amount, and in token cut rupees 100 is deducted. Rupees 100 is deducted from what is demanded. So these are the three kinds of cut motions, right? Fourth one is not, so our answer is C. The Lok Sabha Secretariat comes under the supervision of Ministry of Home Affairs, Ministry of Parliamentary Affairs, Prime Minister Office, or the Speaker of Lok Sabha. The Lok Sabha Secretariat. D. Speaker of Lok Sabha. It is for this reason the Speaker shall continue to hold his office even if the Lok Sabha has been dissolved, because he is also the chairman or secretary, president of the Lok Sabha Secretariat. So it is functional under the Speaker of the Lok Sabha. Question number 235 says vote on account. So this we have already discussed, that if the budget is not passed before 1st of April, the Parliament is authorized to sanction any grant in advance to meet the expenses. Answer is D. Which one of the following statements about the Speaker of Lok Sabha is not correct? He has the power to adjourn the House sine die. What do you mean by House adjourn sine die? For an indefinite period, right? He has the power to summon the House even after the prorogation. He does not have the power to summon or either prorogue. The power to summon and prorogue lies with the President of India. So this is false statement. He continues to be in office, that we have already discussed. He must vacate the office if he ceases to be a member of the Lok Sabha. This is also true. Which one is not correct is he has the power. He has no power to summon or prorogue the houses. Which of the following is not correct with regard to the Speaker of Lok Sabha? The Speaker certify whether a particular bill is a money bill or not. Right? Discussion on a motion for the removal of Speaker is presided over by the Vice President. No. So whenever the removal motion for the Speaker is there, it shall be presided by the Deputy Speaker. For the Deputy Speaker, it shall be presided by the Speaker. During that time, whenever the removal motion is under the place, the Speaker cannot preside. He will be idly sitting in the like the members of the House, right? So this is the false statement. Which one of the following statement is correct with regard to power of Parliament in enacting the budget? It is basically related to taxes. It can increase a tax but cannot reduce. It can increase a tax as well as reduce or abolish it. It cannot increase a tax but can reduce or abolish it. It can neither increase nor reduce a tax. So once a tax has been proposed by government, Parliament cannot increase that. But yes, Parliament can either reduce or abolish the tax. Right? So answer shall be C. Rajya Sabha has equal powers with Lok Sabha. ऐसा ये क्वेश्चन यूपीएससी पूछ चुका, आई थिंक 2015 और 16 में. So Rajya Sabha has equal powers with Lok Sabha in the matters of creating all India services, new all India services. Indeed, here Rajya Sabha has more power. We are talking about equal powers. In amending the constitution, exactly equal power Rajya Sabha and Lok Sabha are having. In the removal of the government, Lok Sabha has exclusive power. And in making cut motions, Lok Sabha has the exclusive power. So equal power of Rajya Sabha and Lok Sabha is in regard to making constitutional amendments. Right, so this one is a current affairs question. Indian Express में आया था. With reference to serious fraud investigation office, consider the following statement. It is a multidisciplinary organization under the Ministry of Home Affairs. Secondly, SFIO is headed by a director in the rank of Joint Secretary to the Government of India. Which of these are correct or incorrect? अच्छा, इसका explanation आपके notes में ही लिखा होगा. You have this explanation? So this is not under the Ministry of Home Affairs. This is under the Ministry of Corporate Affairs. So this is an organization which investigates mainly economic offences, and it has personnel from various other fields. This is why it is called multidisciplinary organization. It has law expert, it has forensic expert, it has auditors. बहुत सारे लोग होते हैं इसमें. But this organization functions under the Ministry of Corporate Affairs, right? So this statement first is false, second is true. Our answer is B. The detail is given in your handout itself. Here, I think this is a repeat question. The parliamentary privileges. Anyhow, the answer is Article 105B. With reference to Padma Awards, again it is also from the newspaper. With reference to Padma Awards, consider the following statement. Government servants, including those working with public sector undertakings, expert doctors and scientists, are not eligible for these awards. Those who are under the service of government, right? Secondly, the first ever non-Indian Padma Vibhushan awardee was Jigme Dorji Wanchuk, Bhutan के हैं, है ना? Third, President of India can annul or cancel someone's Padma Award in case of what is this called? Aggressive misconduct committed by the recipient. First one, whether it is true or false, it's true. You being a government servant, IAS बन जाओगे तो Padma Awards भूल जाना. After you retire, then you start social service, उसके लिए मिल जाएगा. That is a different thing. But performing for the work you have done and you are already taking salary, why should government give you awards? You may be your services may be recognized. That is another thing, right? So first statement is true. Second is also true if it is about the Padma Vibhushan. First non-Indian recipient of Bharat Ratna is any patient to Indian, मतलब okay sir. Bharat Ratna, Khan Abdul Ghaffar. Achha, you should check it, but as far as I know, it's Nelson Mandela. As far as I know. First foreigner. You can Google it later on. Ya fir abhi, not to worry. The President of India can annul someone's Padma Awards. This is also true in case of misconduct committed by that person, right? So all these statements are true here, right? Answer shall be D. Yet this is also question from the current affairs. With reference to charge sheet. Charge sheet is a term which is usually you will find in the criminal trial. है ना, किसी के ऊपर allegations लगाते हैं. If the police after the investigation will file that so and so person, I think as per our investigation is guilty under so many offenses. This is called charge sheet. तो आजकल बहुत लोग के अगेंस्ट चार्ज शीट फाइल होते रहता है. कन्हैया कुमार के अगेंस्ट, अतीक अहमद के अगेंस्ट बेचारा चार्ज शीट ही खत्म हो गया. ठीक है. So with reference to charge sheet, consider the following statement. Like first information report or FIR, it is defined in the CRPC. First statement says both FIR and charge sheet is defined under CRPC. This is the meaning of Mother Teresa. अरे यार उसको कैसे भूल सकते हो? So it's Mother Teresa who has got first Bharat Ratna award. They are non-public documents and enabling their free public access violates the provision of the criminal code or criminal procedure code. So we are considering what is charge sheet. First statement says it is defined under CRPC, so is the FIR. Second says it is not a public document, so you cannot distribute it publicly. But publicly, it is the right of the accused to take the copy of the charge sheet. But should it be given to everyone? अगर दो लोगों के केस, suppose a person A is accused and he is facing the trial, it is their right to get all the documents, all the evidence which is being used against them. But what about the other public? Should I go and take the क्या charge sheet है दे दो? It is violation of someone's privacy. And recently Supreme Court has told that charge sheets are not a public document, right? So this statement is false. These are not the public document. This is true statement, right? They are not the public documents. Now coming to the first statement, whether FIR is defined under CRPC or not, and whether charge sheet is defined under CRPC or not. So charge sheet is defined under section 173 of CRPC, right? Section 154 of CRPC says information in the case of cognizable offense. I have already told you what is cognizable offense. The offenses under which police can arrest any person even without the requirement of a warrant. That is called cognizable offense. So section 154 of CRPC defines information in the case of cognizable offense. It does not define FIR. However, section 173 CRPC defines charge sheet. So ideally the process shall be, process में मैंने आपको बताया है ट्रायल कैसे होता है, क्रिमिनल ट्रायल, पुलिस पकड़ती है तो क्या करती है. So ideally in any case of cognizable offense, information has to be given to the police. If no person is giving the information, police can directly go and investigate and then themselves register the FIR. पुलिस कर सकती है in case of cognizable offense. Now after the registration of FIR, what happens? Investigation should start, right? Investigation करके पुलिस को क्या मिलेगा? Whether the person may be guilty, जिसके ऊपर charge accused, whether during the investigation police can arrest the person who thinks that he or she is accused. So the accused person, after investigation, police may find him guilty or police may think that there is no case against him, right? So in both the cases, police have to do the investigation. That if police thinks that the person is guilty, they will file what? Charge sheet. Where charge sheet is filed? In the court, before the magistrate. If the police thinks that the person is not guilty, they will file what? Closure report. This is called closure report. Case खत्म, उसके आगे केस नहीं चलेगा, पुलिस को ही नहीं मिला तो. If the court thinks that कि closure report के बाद भी, if court thinks that no, पुलिस को कुछ नहीं आया, then court can hand over to the CBI. हाई कोर्ट कर सकती है वो, but ideally इसके बाद केस आगे नहीं बढ़ता. This is the closure of the case. Now after the charge sheet has been filed, the accused will be orally asked. Accused को कोर्ट बुलाएगी, ये देखो भैया तुम्हारे अगेंस्ट ये चार्ज लगे हैं, do you plead guilty? So accused says yes, I plead guilty. इतना शरीफ कोई नहीं होता. So they will say I do not plead guilty. So after charge sheet, it has to be orally dictated before the accused, and he say I plead not guilty. So if not guilty, accused क्या बोलेगा कि मेरे को जबरदस्ती फंसाया जा रहा है, I am not guilty, then court will say the trial will start. So this is the stage after charges has been framed and after the accused has pleaded not guilty, then trial starts. और कंफ्यूजन में हम क्या बोलते हैं, इस पूरे को ही ट्रायल बोल लेते हैं. दिस इज नॉट एक्चुअली द ट्रायल, राइट? तो यहाँ पे अक्यूज्ड बोलेगा नॉट गिल्टी, देन कोर्ट विल से पुलिस को अपना एविडेंस लेके आओ. अक्यूज्ड बोलेगा मेरे पास अपना एविडेंस लेने का मौका दो. द बोथ पार्टीज विल स्टार्ट आर्ग्यूमेंट. सो दिस इज द होल क्रिमिनल प्रोसीजर. इतना आसान नहीं है. 60 to 90 days. It depends upon the various category of offenses. But ideally within 60 to 90 days, police has to file the charge sheet. If police fails to file the charge sheet, there is a right to bail. उसी दिन after the lapse of 90th days, accused is getting a right to claim the bail, even in the case of non-bailable offenses. Right? Often seen in news, a wolf warrior diplomacy is connected with China. It is connected with China. अभी जो आपके कौन है वहां का प्रीमियर, सी जिनपिंग. So this policy has been started by him. With reference to fundamental rights, consider the following statement. This is in context that Supreme Court recently, I think 3 or 4 months ago, came out with a judgment that Article 19 cannot only be claimed against the government, it can also be claimed against the fellow citizens, right? So this is in context with that. A horizontal application of right mean it can be enforced only against the state, while a vertical application of right means it is enforceable against the other citizens also. It is interchanged, right? Horizontal means, firstly, if I am saying that this right can only be applied vertically, this means you can only claim against state. But if any right is applied horizontally, you can claim both against state and against the other citizens also. In Justice K.S. Puttaswamy versus Union of India, Supreme Court unanimously upheld the privacy as a fundamental right. So this is true judgment, right? This is B. Which of the following statements are not true with the reference of process of delimitation? I think ये भी repeat question है. नहीं, थोड़े से ऑप्शन चेंज है. The delimitation is carried by Independent Delimitation Commission appointed by the Election Commission of India. गलत है. This is by President. The Delimitation Commission is appointed by the President. So this will be our answer. This is not correct. This is false statement. But let's see other answers, other options also. The draft proposal of the delimitation commission are published for the public feedback. It is published under Article 82. Parliament is to enact the delimitation act after every census. After the delimitation act is enacted, the delimitation commission is formed. In the history of Indian Republic, delimitation commission have been set up 4 times, right? Question number 247. Which of the following expenditures shall be charged on the consolidated fund of India? Emoluments and allowances of president and other expenditure relating to his office. Emoluments and allowances of prime minister and other expenditure relating to his office. False. Expenditure charged. These are the expenditure made from prime minister ke, right? But we are asking about which are the expenditure charged upon, because the expenditure which are headed charged, they are not voted, they are non-votable. Expenditure made from, they are votable. तो प्राइम मिनिस्टर का मेड फ्रॉम है, उनको इंडिपेंडेंस देने का कुछ सोचा नहीं है संविधान ने, है ना. दे आर देमसेल्फ द पर्सन हु सीज द इंडिपेंडेंस ऑफ अदर पर्सन्स. Third one, salaries and allowances of chairman and the deputy chairman of the council of state charged. Salaries and allowances of speaker and deputy speaker of the Lok Sabha charged. So only 2 is not here. So 1, 3 and 4 shall be the option. Which one of the following motions has precedence over every other motions? Calling attention, half an hour discussion, adjournment motion and a resolution by both the houses jointly. Adjournment motion. So this includes a severe criticism, severe censure against the government. So once it has been adopted, every other business ongoing in the house shall be subsided and it will take precedence over all the other business, right? So it is adjournment motion. 249. Consider the following statements. The allocation of seats in the Rajya Sabha to be filled by the representative of states and of union territories in accordance with the provision in that behalf contained in the 4th schedule of the Constitution of India. The representative of each state and union territory in the Rajya Sabha are elected by the members of the Legislative Assembly of the state and body functioning as legislature of the union territory in accordance with the system of proportional representation by the means of single transferable vote. Two is saying each state and union territory. So each state and union territory are not represented. It's only Delhi and Pondicherry. These are the 2 union territories which has the representation in the Council of State. Other union territories, simply they are the part of union, directly being governed under the by the union. So why would they need representation under the Council of States, right? So this one becomes a false statement, and first one is correct. So this is one only. The question asked orally in the question hour in the house is called oral question, short notice question, starred question, unstarred question. Starred question. So starred actually क्या होता है कि every member can ask questions from the ministers. They will have to give the list to the parliamentary secretary. So the question which they want an oral answer, those questions will be star marked in the list. तो उसको इसलिए बोलते हैं क्या, starred question. So starred question are those question where minister needs to come to the house, he needs to answer the question and also a supplementary question can be asked over it. क्योंकि जब मैं ओरली बात कर रहा हूं आपसे, एक क्वेश्चन का आंसर करता हूं तो आप उस पलट के पूछ सकते हो, लेकिन जो मैंने लिख के दे दिया उस पर आप कैसे पूछ सकते हो दूसरा क्वेश्चन. So supplementary questions are allowed only in the cases of starred question, not in the case of unstarred question, right? So this handout is ended. We shall start from next. Okay. बाहर से बुलाने की। दूसरा ठीक है, ये वाला। क्वेश्चन नंबर 251। I've repeated the question. सेम ही है क्या दोनों? Yes. यहाँ से 270. When an ordinary bill is referred to a joint sitting of both the houses of Parliament to one only 277. When an ordinary bill is referred to a joint sitting of both the houses of Parliament, it has to be passed by simple majority of the total, 2/3 majority of the total, simple majority of the total number of the members in the house, in both the houses, 2/3 majority of the total number of members of both the houses present and voting. A. So it is simple majority of the total members of the both the houses combined. It is 543 plus 245. उसमें से जितने आए हैं present and voting, simple majority उसका 50% plus 1, right? सिंपल मेजोरिटी ऑफ द टोटल मेंबर्स, दिस मींस 543 लोकसभा में होंगे, 245 राज्यसभा में होंगे, दिस गिव्स 778, है ना? यही है ना? 88, right? So 788. Suppose that out of this 788, 500 members are present and they have voted. Now what is majority? 250. So ये होगा, this is also saying that simple majority of the total members of both the houses present and voting, right? Question number 278. The economic cut motion seeks to reduce the proposed expenditure of a demand for grant by rupee 100, rupee 1, a specific amount, unspecified amount, specific amount. Consider the following statements. After the annual financial statement, that is budget, is presented before the House of Parliament, it is examined by the Public Accounts Committee. No, it is after the year has passed, CAG has submitted the report, then it goes to the Public Account Committee. The Public Accounts Committee examines the report of the CAG, Comptroller and Auditor General of India, after it is laid before the Parliament. So this is true. So first is false, second is true. Consider the following statements. The Parliamentary Committee on the Empowerment of Women was constituted in 1997. Second statement, the Parliamentary Committee on the Empowerment of Women consists of 20 members of the Lok Sabha and 10 members of the Rajya Sabha. Second one is correct. It consists of 30 members, 2:1 ka ratio, 20 plus 1. It was constituted in 1907 or not? It is also correct. It was constituted in first time in the 1997. What is the role of this committee? So that is the general thing, but basically the way Public Accounts Committee shall examine the report of CAG. So National Commission of Women is also presenting a report to the President of India every year, that is to be laid before the Parliament. Now this committee will examine that report which has been presented by National Commission for Women. So both these statements here are correct. Which one of the following committees is not a standing committee of the Parliament? What do you mean by standing committee? Permanent committee, right? कौन सा नहीं है इसमें से? Consultative Committee of Ministry of Finance. Other three are the standing financial committees: Public Accounts Committee, Estimates Committee, and Committee on Public Sector Undertaking. These are standing committee. These are the permanent committee. Consultative is an ad hoc which is created as and when needed, and once their purpose is finished, this committee shall also be abolished. Right? Answer is D. The chairman of Public Accounts Committee of Parliament is appointed by Speaker of Lok Sabha, Prime Minister of India, President of India, or the chairman of Rajya Sabha? Speaker of Lok Sabha. So this person, chairman of Public Accounts Committee, shall be appointed by the Speaker of the Lok Sabha. Answer is 1. Question number 283. Which of the following are helped by CAG in their work of exercising parliamentary control over the executive? After the CAG prepares the report, he shall submit to the President, who will lay before the houses of the Parliament. It is then transferred to the various committees. So committee, the CAG report on the public sector undertaking is transferred to the Committee on Public Sector Undertaking. जो appropriation account पे report होता है, Public Accounts Committee पे चली जाती है. So all these reports are transferred to the respective committee. But एक committee ऐसी है which can, there are a Public Accounts Committee है which can call the CAG for their assistance. Wherever there is a confusion in the report for committee को समझ नहीं आ रहा, they can seek the help of CAG. This is why CAG is called also the friend, philosopher and guide of the Public Account Committee. तो एक तो मैंने बता दिया, this is there. Estimate Committee में हाँ, so CAG will not be helping Estimates Committee. CAG does not appear before the Estimate Committee, right? It appears before the Public Accounts Committee. अब देखो 3. Now what about Committee of Privileges? Committee on Privileges किस चीज के लिए होती है? If there is any breach of parliamentary privilege, क्या लेना देना उससे? CAG is a financial person. So यहाँ भी वो नहीं आएगा. 1 and 4, right? Which of the following committee recommended for the creation of Committee on Public Undertaking? Krishna Menon Committee recommended for the creation of Committee on Public Sector Undertaking. Question number 285. Which of the following pairs is not correctly matched? Committee on Petition, it is the standing committee to inquire. Committee on Government Assurance, standing committee to scrutinize. Committee on Subordinate Legislation, standing committee to inquire. Joint or select committee on bills, ad hoc committee to inquire. C is incorrect. Why? This committee will not make the subordinate laws, right? What do you mean by subordinate legislation? First is that, so ideally Parliament will provide a skeletal laws, मनरेगा बना दिया, but the rules are to be framed by the executive. This rule making power is called delegated legislation or subordinate legislation. So whether those powers which executive is exercising, these are actually the law making powers. Executive exercise every now and then. आपने सुना होगा सेज रूल्स के बारे में, स्पेशल इकोनॉमिक जोन्स रूल, or you might have heard about there is a term in your syllabus, environment impact assessment rules. So all these are the rules. Rules are not made by the Parliament, they are made by the executive. So whether executive while making the rule are following the directions which have been given by the law, or they are breaching those, or whether they are violating their own jurisdiction, they are creating any new thing, whether they are violating the rights of the individual. So all these things have to be scrutinized by whom? Committee on Subordinate legislations, right? So this is not to inquire on anything कि पार्लियामेंट के प्रिविलेज का ब्रीच हो गया, ऐसा कुछ इंक्वायरी कमिटी नहीं है ये. दिस इज अ स्क्रूटिनाइजिंग कमिटी, राइट? आंसर इज सी. The speaker is the ex officio chairman of rules committee, committee of privilege, committee of public undertaking, committee on government assurance. What does this committee does? A committee on government assurance क्या करती है? हाँ, if minister is coming to house and doing anything, any promise on the floor of house, whether that is getting fulfilled or not, this is to be seen by committee on government assurance, right? Speaker इनमें से किसका chairman होता है? रूल्स कमेटी का. Which one of the following is not a function of committee on subordinate legislation? To evolve a systematic pattern of terms of delegation, to improve the methods of publicity of these rules, to lay down rules and regulation on the table of the house, to achieve uniformity in the rule making process. Laying down is not the function of this committee. After the rules have been laid down, it is then transferred to the committee for consideration. ले डाउन कौन करेगा? एग्जीक्यूटिव करेगी. Consider the following statements. A bill pending in the legislature of a state shall not lapse by the reason of prorogation of the house or houses thereof. This is about the legislature of the state, but the same concept shall apply. A bill pending in the legislative council of a state which has not been passed by the legislative assembly shall not lapse on the dissolution of the house. A bill pending in the legislative council of the state which has not been passed by the legislative assembly shall not lapse on the dissolution of legislative assembly. Why it should lapse? The bill is there in the legislative council. Now bill legislative council में है. It has initiated in the legislative council. It has not reached the legislative assembly still. Parliament में भी तो ऐसा होता है ना. If the bill has originated in the council of state, राज्यसभा में होता है, but अभी वो लोकसभा तक आया ही नहीं है. That shall not lapse. If it is presented, then ऐसा कहाँ लिखा है? If it is presented, if it has come and it is pending, अगर if it is presented होता तो बोलता it is pending in the legislative assembly. But the bill is pending in the legislative council. It is not pending in the legislative assembly, है ना? In this case, it is similar to that of Rajya Sabha with the dissolution or lapse. Rajya Sabha से inferior या फिर lesser power legislative council को कब है? In final passing of the bill that we have already seen कि 3 महीने and then once it is repassed then 1 महीने, तो maximum 4 month तक delay किया जा सकता है, right? But यहाँ lapse करना ना करना same concept लगाओगे आप, right? So both this statement are correct. Consider the following statements. Parliament may by law provide for the abolition of legislative council of a state having such a council or for creation of such a council in the state having no such council. This is exact bare act copied constitution का article 169 तुरंत छापा हुआ है ये. तो इसमें क्या कहता है कि suppose that in a particular state where is already there is a legislative council, for that parliament can abolish that, and where there is no legislative council, parliament can create a legislative council, right? ये parliament कर सकती है. This is the power of the parliament. Now second is talking about the number. The total number of the members in the legislative council of a state having such a council shall not exceed 1/2 of the total number of the members in the legislative assembly of that state. 1/3, right? What is the maximum number of persons? What is the maximum number? What is the maximum strength of the legislative assembly? 500, right? That is 500. What is minimum? 60. इस स्टेट में कम है इससे? How? By special article 371. So there are some state where the minimum number is even lesser than 60. That is possible because they have been exempted under special status, that is article 371. So this is the minimum. It is for the legislative assembly. Now for the legislative council, what is the minimum? 40. Any state which needs to create legislative council should have a minimum 40 in that legislative council after it has created, and maximum is 1/3 of respective legislative assembly. So यहाँ पे क्या लिखा है? 1/2, that is false, right? So 1/3. This statement is false. This is true. Our answer shall be A, right? The upper chamber of the state legislature, besides other members, consists of. Now, what is the process of election or nomination of peoples in the state legislative council? Upper chamber means council of the state legislatures, right? Legislative council. So ideally, there will be 1/3 persons who are directly elected by the people legislative assembly. So 1/3, suppose that there are 99 members in a legislative council. So 1/3 shall be elected by the persons who are already MLAs, but not from amongst themselves. They should be persons who are not the member of the legislative assembly. मतलब 1/3 सीट वैसे लोगों को इलेक्ट किया जाएगा जो ऑलरेडी लेजिस्लेटिव असेंबली के मेंबर्स नहीं है, लेकिन उनके इलेक्शन में वोट कौन करेंगे? जो लेजिस्लेटिव असेंबली के मेंबर्स हैं, राइट? वोटर्स विल बी द मेंबर्स ऑफ द लेजिस्लेटिव असेंबली एंड दे विल फिल द सीट्स with the people who are from the outside. 1/3 the local bodies के representatives they will elect, right? बचा कौन? 1/3. अब इस 1/3 में बहुत बवाल है. 1/3 के लिए 1/12 are elected by the teachers above primary level. Teachers above the primary level from that state, and 1/12 by the graduates. So 1/12 teachers above primary, 1/12 graduates, यहाँ पे आप लोग वोट कर सकते हो, and 1/6 are nominated by governor. From which field? There is one extra here, cooperative society. So governor will nominate 1/6 of the member in the legislative council from the fields of literature, art, science, social service and cooperative societies, right? इन 5 जगहों से the governor can nominate. So यहाँ पे हमारा जो होगा first one is the correct choice. Question number 291 says the quorum to hold a meeting of a house of the state legislature shall be. What is the quorum to hold a meeting of the parliament? 1/10. And what is that for state legislature? But suppose karo there is one legislative assembly with 60 members. 1/10 is chalega usse? Nahi. So it should be ideally either 1/10 or at least 10 members. So at least 1/10 member, but एक 1/10 से भी काम चल जाएगा. If 1/10 is more than 10, that will be 1/10, or if 1/10 is less than the 10, then minimum 10 should be there. So it is 10 members or 1/3 of the total membership of the house. Consider the following statements. Question number 292. Consider the following statement. No discussion can take place in the legislature of a state with respect to conduct of any judge of the Supreme Court as per the provisions of the Constitution of India. Second, there is no restriction on the discussion to take place in the legislature of a state with respect to conduct of any judge of the state high court as per the provision of Constitution of India. Courts cannot inquire into the proceedings of legislature as per the provisions of the Constitution of India. No discussion can take place. So technically, neither the judges of High Court nor the judges of Supreme Court, their conduct cannot be discussed in the state legislature. The removal process for Supreme Court and High Court judges are same, and that prescribes the removal by the Parliament, not by the state legislature. Second statement is false. First is true. Conduct of judges of Supreme Court cannot be discussed in the state legislature, nor even for the High Court. It cannot also be discussed for the High Court. So this makes second statement as false. Third is true. that courts cannot inquire into any proceedings which is undertaking in the legislature, either of the parliament nor of the state legislature. So third one is true. Answer shall be C, 1 and 3. Statement number 2. Article, there is removal is article 1 to 4. Parliament, but there is one article with regards to the High Court that says for the removal article 124 shall apply. वो एग्जैक्ट वही आर्टिकल है, मैं देख के बताता हूँ. Any judge, right. बट ये जो रिमूवल का प्रोसेस है दैट इज रिटेन की जैसा सुप्रीम कोर्ट के लिए होता है वैसा ही हाई कोर्ट के लिए होगा. So the conduct of judges of Supreme Court discussed where? In Parliament. तो सेम किसके लिए होगा? हाई कोर्ट के लिए. मतलब वो कहाँ डिस्कस किया जा सकता है? पार्लियामेंट में किया जा सकता है. हाँ, ऐसा एक्सप्रेस नहीं लिखा है, लेकिन कहाँ किया जा सकता है ये तो लिखा है. दिस इज एक्सक्लूसिवली गिवन टू द पार्लियामेंट ना, तो वो हम इस वजह से नहीं कर सकते. और नीदर प्रोविजन में कॉन्स्टिट्यूशन में ये भी तो नहीं लिखा है कि वहां लिखा डिस्कस किया जाएगा. चलो, तो इसका आंसर हमने क्या लिया है? आंसर सी, 1 and 3. The Legislative Assembly of the state can pass a resolution to abolish or create a legislative council in the state. What is the majority required? Absolute majority, and that should be more than 2/3 of the present and voting. If there is any legislative council in the state that needs to be abolished, same majority. That needs to be created if the state has no legislative council, again the same majority. So this is a resolution which needs to be first passed by the local state assembly, then it will be given to the parliament, which by law can create the legislative council and then or either can abolish. What is the time limit which is given for a non-money bill to be sent to the state legislature by the governor for reconsideration? ऐसा कोई टाइम लिमिट प्रिस्क्राइब नहीं है, राइट? नो टाइम लिमिट हैज बीन स्पेसिफाइड. Consider the following statements. A bill, if enacted and brought into operation, would involve expenditure from consolidated fund of state, must have been recommended by governor to a house of the legislature of the state for consideration of the bill. कहने का मतलब any such bill which is a money bill indeed. So money bill requires the prior recommendation of the governor. Second statement says such a bill cannot be passed by the house without the recommendation of the governor has been attained. Yeah, for the consideration of the bill, governor has given the recommendations. Both are similar statement, but एक कह रहा है कि पास नहीं किया जा सकता, एक कह रहा है इंट्रोड्यूस नहीं किया जा सकता. Both are correct. एक बार दोबारा से देख लो. A bill which if enacted and brought into operation would involve the expenditure from the consolidated fund of the state. This means the money bill must have been recommended by the governor to a house. Governor उस legislature के house को पहले recommend करेगा, then it only can be introduced. The meaning of this statement. Then it says such a bill cannot be passed by the house if the prior recommendation is not attained. Both the statements shall be true. Along with the budget, this is actually a previous year question paper. Along with the budget, the finance minister also places the other documents before the parliament, which include the macroeconomic framework statement. Therefore, said document is presented because of it is mandated by long-standing parliamentary convention, Article 112 and 110 of the Constitution, Article 113 of the Constitution, provision of the FRBM Act. So, provisions of the FRBM Act. There is an act which prescribes that the fiscal deficit should be reduced to 60% नहीं 3% of the GDP. वो हर साल अमेंड कर देते हैं क्योंकि हम उस टारगेट को कभी अचीव नहीं कर पाते हैं. And the revenue deficit should be eliminated gradually. It should be brought to zero. And this act also prescribes that every year government should along with the budget present this macroeconomic policy framework. So this is mandated under the provisions of FRBM Act. Question number 297, with reference to Parliament of India, which of the following parliamentary committee scrutinizes and reports to the House whether the power to make regulation, rules, sub-rules, bylaws, etc. conferred by the Constitution or delegated by the Parliament are being properly exercised by executive within the scope of delegation or not? This is also a previous year question paper. Answer is Committee on Subordinate Delegation. Question number 298, for the election to the Lok Sabha, a nomination paper can be filed by, question asked in 2017, anyone residing in India, a resident of constituency from which the election is to be contested, any citizen of India whose name appears in the electoral roll of the constituency, any citizen of India. C. हालांकि स्टेटमेंट इनकम्प्लीट है because there is age criteria which is missing. You get your names registered only at the age of 18, but you are eligible to contest the election at the age of 25. But जो इसमें से best possible option है, this is, however, this qualification is not prescribed under the Constitution. This is given under Representation of People's Act, right? With reference to the Parliament of India, consider the following. A private member's bill is a bill presented by the member of Parliament who is not elected but only nominated by the President of India. Recently, a private member bill has been passed in the Parliament of India for the first time in the history. Both are false. Private member bills can be categorized into two if you classify by who is introducing the bill. One is public bill or government bill, which is introduced by a member of the Council of Ministers. Any other member, be it elected or nominated, be it from Rajya Sabha or Lok Sabha, they can introduce the bill. That is called private member bill, and it is not for the first time. बहुत पहले in the starting 5 or 6 years ही पहला private member bill pass हो गया था. And this private member bill becomes important because recently, I think in December, someone introduced a private member bill for uniform civil code. कोई मीना करके एक MP हैं जिन्होंने यूनिफॉर्म सिविल कोड को लाने के लिए एक प्राइवेट मेंबर बिल डाला है. वो बिल कहाँ गया पता नहीं. So both these statements are false. D shall be the answer. The Parliament of India exercise control over the functions of the Council of Ministers through adjournment motion, question hour and supplementary questions. D, all of the above. These are the tools of Parliament where Parliament holds executive answerable, accountable. Adjournment motion, censoring the government. Question hour, asking question. Supplementary question, also a kind of question. So D shall be the answer, all of the above. When a bill is referred to a joint sitting by both the houses of Parliament, it has to be passed by. Concept we have already discussed, question we have also discussed, but it's again a PYQ. So a simple majority of members present and voting, 3/4 majority, 2/3 majority, absolute majority. Simple majority of the people present and voting. Consider the following statements. The Legislative Council of State in India can be larger in size than the half of the Legislative Assembly of the particular state. The Governor of a state nominates the chairman of the Legislative Council for the particular state. Both the statement will be false. यहाँ पे क्या होगा? 1/3 that we have already seen. 1/3 से ज़्यादा नहीं होना चाहिए. And the chairman of the Legislative Council are not nominated, rather elected by the members from amongst themselves. हाँ. So it depends upon how Parliament will make the law creating the Legislative Council for the Goa. Ultimately, Legislative Council गोवा में बनेगी कैसे? Parliament बनाएगी. पर उस समय मान लो उसने बता दिया नहीं 20 में ही काम चलाना पड़ेगा तो हाँ मतलब either the Parliament will then increase the council legislative assembly या तो उसको बढ़ाइए 20 मेंबर के लिए काउंसिल देना तो बेवजह लगता है तो वैसा तो नहीं करेगी. एटलीस्ट देयर शुड बी 40 50 60 मेंबर्स एटलीस्ट. उससे ज्यादा तो जोनल काउंसिल में होते हैं हमारे पास. तो उसके लिए लेजिस्लेटिव काउंसिल नहीं बनाएंगे गोवा के लिए. अगर बनाने की जरूरत पड़ी तो दो पॉसिबल ऑप्शंस है. इधर लेजिस्लेटिव असेंबली ऑफ गोवा शैल बी enlarged first, then a council should be given, or parliament will give another exemption. जिस तरह आर्टिकल 371 में गोवा को लेजिस्लेटिव असेंबली के लिए एग्जामिनेशन दिया है, लेजिस्लेटिव काउंसिल के लिए भी दिया जाएगा। अभी द 6 स्टेट दे आर वेरी पॉपुलस स्टेट जहाँ पे लेजिस्लेटिव काउंसिल है, तो वहाँ पे ये 1/3 ही चल जाता है, वहाँ पे ठीक ठाक लोग आ जाते हैं। लाइक यू सी बिहार इज हैविंग अराउंड 243 में या ऐसे कुछ 230 या 240 मेंबर्स हैं, उसका 1/3 करोगे बहुत आएंगे, 80-90 लोग आ जाते हैं। यूपी में और महाराष्ट्र, कर्नाटक, ऑल दीज आर द बिग असेंबलीज, तो वहाँ पे होता है, राइट। So far we have discussed somewhere around 300 questions and we have covered topics like fundamental rights, executive and parliament. So legislature, executive we have covered, parliament, fundamental rights we have covered. We are left with judiciary, we are left with certain trivial provisions, and 50 questions we will be doing from bare acts and 50 again from the current affairs जो express होगा. Every day I include 10 something questions from the Indian Express, वो आपको दिख जाता होगा, जो थोड़े डायरेक्ट काइंड ऑफ क्वेश्चन होंगे और रीसेंट काइंड ऑफ क्वेश्चन होंगे, ठीक है। सो विल मीट फॉर द नेक्स्ट टाइम एंड देन वी विल डू टॉपिक्स, आपको पहले बता देंगे, देखते हैं कौन सा प्रिपेयर हो जाता है पहले, ठीक है। प्रोबेबली जुडिशियरी वी शैल डू, राइट। थैंक यू।